Stop. Before you close this video, I need you to hear something that most people in your situation are not being told. Right now in 2026, USCIS is sitting on a backlog that is quietly swallowing green card cases whole. Cases just like yours. And what is happening at service centers across this country is not evenly distributed. It is not random. And it is absolutely not something you have to just accept and wait out. The people who are moving through this system faster right now, they are not luckier than you. They know something you probably don't. And in the next 12 minutes, I am going to give you that exact same information, broken down step by step, so that you can stop watching your priority date crawl forward and start taking real strategic action on your case. I want you to understand something before we go any further. If you are waiting on a pending I-130, a pending I-140, or you have already filed your I-485 and you are sitting there refreshing your USCIS case status every single day, wondering why nothing is happening, and this video is for you. Because there are moves you can make right now. Legal, documented, strategic moves that can shave months off your waiting time. And if your case has gone so far off the rails that no amount of standard strategy is going to fix it, I will even tell you about the legal tool that immigration attorneys are increasingly using in 2026 to force USCIS to act. So stay with me all the way to the end, because the last strategy I share might be the most important one you have ever heard. Welcome back to Immigration Path USA, the channel committed to cutting through the noise, the rumors, and the misinformation that floods the internet when it comes to U.S. immigration. Before we dive in, I need to share a brief but important disclaimer. I am not an attorney. Nothing in this video constitutes legal advice. This content is for educational and informational purposes only. Every immigration case is different, and you should always consult with a licensed immigration attorney or accredited representative for guidance specific to your situation. With that said, let's get into it. Let's start with the hard truth about where processing times actually stand right now in 2026, because the numbers are not what most people expect when they first look them up. USCIS publishes processing time estimates on their official website, updated weekly. And on the surface, some of those numbers look manageable. But here is what they are not telling you in bold letters at the top of that page. Those estimates reflect the 80th percentile of cases, meaning 20% of cases are taking longer, some significantly longer. And when you factor in requests for evidence, service center reassignments, and the ripple effects of an agency that processed Form I-1 to 29 petitions at a rate over 80% slower than just 1 year ago, the picture becomes a lot more complicated. Let's break it down by form, because the system does not treat everyone the same, and your strategy depends entirely on which stage of the process you are in. If you are at the I-130 stage, that is the petition for alien relative, the first step in family-based immigration, here is what the data shows in 2026. If you are an immediate relative of a U.S. citizen, meaning a spouse, an unmarried child, under 21, or a parent, you are looking at roughly 10 to 14 months for I-130 approval alone. If you are in the F2A category, meaning you are the spouse or unmarried child of a lawful permanent resident, a green card holder, brace yourself, because that I-130 is currently taking up to 35 months to process. That is almost 3 years, just for the petition. Before you even get to file the I-485, that number alone should make you understand why strategy is not optional right now. It is essential. Now, if you are on the employment-based side, waiting on your I-140, the immigrant petition for alien workers, the standard processing time sits between 2 and 8 months, depending on your service center, your category, and the current workload distribution at USCIS. The Texas Service Center handles a significant volume of employment-based petitions, and the delays there have been real and measurable. But here is something critical to understand. The I-140 is one of the forms where you actually have a weapon available to you that can change everything, and most people are not using it. But here is the catch that most people are missing, and I want you to pause whatever you're doing and really hear this. The I-485, your actual green card application, the application to register permanent residence or adjust status, cannot be expedited through premium processing. It cannot. There is no form you can pay extra money to file to make your I-485 move faster. It currently takes an average of 8.2 months for family-based cases, and employment-based timelines vary significantly based on visa bulletin movement and your country of chargeability. So the real question becomes, how do you accelerate everything that happens before the I-485 reaches an adjudicator's desk? Because that is where the game is won or lost. And that is exactly where premium processing comes in, specifically Form I-907, the request for premium processing service. This tool is available for certain employment-based I-140 petitions, including EB-1 extraordinary ability cases, EB-2, EB-3, and the EB-2 national interest waiver. The current fee is $28.05, and what does that fee buy you? It buys you a guaranteed decision on your I-140 within 15 business days. Compare that to the standard processing window of up to 8 months, and you start to understand why this is not a luxury. For the right applicant, it is a necessity. Here is why this matters strategically beyond just getting an answer faster. When your I-140 is approved, your priority date is established. That priority date is your place in line for a visa number. And in employment-based categories, particularly for applicants from high-demand countries, that priority date is everything. Every month of delay in getting your I-140 approved is a month you are losing in the visa bulletin race. Premium processing through Form I-907 compresses that gap dramatically. For EB-1 multinational managers and EB-2 NIW applicants, the premium processing window is 45 business days, still dramatically faster than the standard timeline. Now let me introduce you to the strategy that separates the applicants who sail through USCIS from the ones who get stuck in a nightmare of back-and-forth correspondence for months on end. It is called front-loading, and it is the single most powerful thing you can do to protect your case from the thing that destroys timelines more than anything else: the RFE, the request for evidence. When USCIS issues an RFE on your case, it is not just a letter asking for more documents. It is a pause button on your entire application. Your case stops moving. You have a response deadline, typically 87 days, and until you respond and USCIS reviews your response, nothing else happens. An RFE can add anywhere from 3 to 6 months or more to your processing timeline. And here's the painful part. Many RFEs are triggered not because of something wrong with the applicant, but because the initial filing was not comprehensive enough. The officer reviewing the petition did not have enough evidence in front of them to make an approval decision. So they sent a request, and now your case is on hold. Front-loading means you submit a petition so thoroughly documented, so clearly organized, so rich with supporting evidence, that the adjudicating officer does not have a single question left unanswered. You are essentially making their job so easy that approval is the path of least resistance. For an I-140, this means submitting detailed reference letters that speak specifically to your qualifications, comprehensive documentation of your credentials, evidence of your employer's ability to pay the proffered wage, and any supplemental materials relevant to your specific EB category. For family-based I-130 petitions, it means submitting a complete, well-organized package of relationship evidence up front, not waiting to be asked. This is where it gets critical for anyone waiting on a green card, so I want you to hear me clearly. A well-prepared, front-loaded petition does not just avoid RFEs. It signals to the adjudicating officer that this case is professionally prepared, that the applicant is serious, and that the documentation is reliable. That matters more than most people realize inside a system that is processing millions of petitions simultaneously. Now let me tell you about a real family, and I am going to call them the Ramirez family to protect their privacy. Carlos and Maria Ramirez had been in the United States for 11 years. Carlos had been working on an H-1B visa, sponsored by his employer. His employer filed an I-140 on his behalf in the EB-2 category, and it was approved. His priority date was current. They filed the I-485 for the entire family, Carlos, Maria, and their 2 children. 8 months went by, 9 months. Then they received a request for evidence. USCIS wanted additional documentation regarding Carlos's educational credentials and the employer's ability to pay the proffered wage for the entire duration of the green card process. The family's attorney had submitted a solid initial package, but certain supporting documents had not been included because, at the time of filing, they assumed standard documentation would be sufficient. The RFE response process took 2 months to prepare properly. Then they waited another 4 months for USCIS to review the response. What should have been a 9 to 10 month process turned into nearly 18 months. Carlos's employment authorization document expired during that window, creating a brief but stressful gap in his ability to maintain his employment status without interruption. The family made it through, their case was eventually approved. But those additional 8 months cost them in stress, in attorney fees, and in time they will never get back. And the single variable that would have changed that outcome? A front-loaded petition from day one. So let us talk about what you actually do right now. Here is your 3-step action plan. Step 1. Know exactly where your case stands and what your specific leverage points are. Go to the USCIS official website and use the Case Processing Times tool. Select your form type, your form category, and the service center listed on your receipt notice. That is Form I-797C, the Notice of Action. The tool will show you the current processing window. More importantly, it will show you what they call the case inquiry date. This is the date at which your case has been pending long enough that you are entitled to submit a formal case inquiry. If your receipt date is earlier than that inquiry date, you can submit an e-request directly through your USCIS online account. Do this, document it, and create a free USCIS online account if you have not already, because it gives you real-time case updates, digital access to your receipt notices, and the ability to respond to RFEs electronically rather than waiting for mail. Step 2, audit your petition for RFE vulnerability before you file, or right now if you have not yet filed. This means going through your application package and asking the question, if an officer only had this evidence and nothing else, would they have everything they need to approve this case? If the answer is anything other than a confident yes, you need to add more. For employment-based petitions, reference letters that are specific, not generic. Financial documentation from the sponsoring employer. A clear organizational chart if the position involves management. For family-based petitions, joint financial records, shared lease agreements, or mortgage documents, photographs spanning the duration of the relationship, sworn affidavits from people who know the couple. Do not hold anything back. Submit it all up front. Step 3. Understand your escalation options before you need them, because the immigration landscape in 2026 is moving fast and unpredictably. If you are an employment-based applicant eligible for I-140 premium processing and you have not yet filed Form I-907, evaluate that decision seriously. The 2,805 fee is significant, but weighed against months of additional waiting, the potential cost to your employment authorization, and the strategic value of establishing your priority date as early as possible. For many applicants, the math is clear. And now I need to talk about the option that nobody wants to use, but that an increasing number of applicants and their attorneys are turning to in 2026 when all other options have been exhausted. It is called a Writ of Mandamus. This is a legal action filed in federal district court that essentially asks a federal judge to compel a government agency, in this case USCIS, to perform a duty it is legally obligated to perform, which in an immigration context means make a decision on this case. Courts have consistently held that USCIS has a legal obligation to process applications within a reasonable time. When that obligation is not being met, when cases have been pending for years without any meaningful movement and without any legitimate explanation, a writ of mandamus lawsuit can be filed to force the agency to act. This is not a casual step. It requires an immigration attorney. It carries costs. And it is not guaranteed to result in an approval, only in a decision, which could theoretically be a denial. But for applicants whose cases have been trapped in bureaucratic limbo for years with no end in sight, it has proven to be an effective tool for forcing movement. If your case has been pending well beyond the standard processing window, you have submitted inquiries, you have responded to every RFE, and USCIS still has not acted. Ask an immigration attorney about whether a writ of mandamus may be appropriate for your specific situation. Here is the broader picture you need to understand about where immigration policy and USCIS operations are heading for the rest of 2026. Processing times for some forms, particularly the I-129 for temporary workers, have increased more than 80% compared to a year ago. That kind of surge does not happen in isolation. It reflects a combination of increased filing volumes, agency staffing, and resource allocation decisions, and the ripple effects of policy changes at the Department of Homeland Security level. What that means for you is that the window of relative predictability that existed even 18 months ago is narrowing. Cases that seemed on track are getting caught in unexpected delays. Service center reassignments are happening mid-case, and the applicants who are navigating this successfully are the ones who prepared before the delays hit, not after. The legislative and administrative landscape remains fluid. Any significant change to per-country visa limits, which have been the subject of ongoing congressional debate, would dramatically affect wait times for applicants from high-demand countries, particularly India and China. The monthly visa bulletin, published by the Department of State and updated in coordination with DHS, is the document you need to be watching closely every single month if you are in a preference category. Your priority date and the bulletin's application final action dates determine whether you can move forward. 1 month's advancement in those dates can open a filing window. 1 month's retrogression can close it. This is not a process where you set a reminder for 6 months from now. It is a process that requires active monthly attention. Your green card is not just a document, it is freedom. It is the ability to change employers without starting the process over. It is the ability to travel internationally without the anxiety of visa renewals. It is your path to citizenship. And it is too important to leave to chance or passive waiting when there are real, legal, documented strategies you can deploy right now to protect your case and shorten your timeline. Here is what I need you to do today. Go check your USCIS case processing times and your case inquiry date. Audit your pending petition for RFE vulnerability. And if you are in an eligible employment-based category and you have not evaluated premium processing through Form I-907, do that evaluation today. Do not let another month pass without taking at least one proactive step toward protecting your case. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential.